Mr. Roberts.
My lords, my lady, because this is an appeal against the judge's order, it's convenient to start with that. You've seen it, I hope, at page 44 of the Court Appeal Bundle. And the relevant paragraph is paragraph 1. I make 3 points on that.
Sorry, just bear with me a moment.
First, the judge only struck out paragraphs 32.2 and 32.3 of the petition. He didn't strike out what has been referred to as the buy-in claim in paragraph 32.1 or the application for an order under section 9962C in paragraph 32.4. Secondly, he struck out those paragraphs so far as they relate to the first respondent. You probably picked up that was because the third and fourth respondents, Cyprus and BVI, have never been served with the petition. The petitioner hasn't obtained permission to serve it on the amount of the jurisdiction. The strikeout application was made by the first respondent alone. And thirdly, he struck out those two paragraphs on the ground that they are an abuse of the court's process. I think it's fair to say that those words don't really add anything to the order, which would achieve precisely the same effect without them. I think they were intended to be included as a pithy encapsulation of the judge's reasoning, but of course in that regard they don't provide any substitute for his reasons judgment. My lord and my lady will have seen in the judgment that the judge's central reason for holding that the paragraphs in question were an abuse of process was essentially that the petitioner should pursue them as a derivative claim, which would require him to obtain permission in accordance with Part 1 of Chapter 11 of the Companies Act 2006. And the petitioner had not obtained such permission and was not therefore in a position to prosecute such claims. Importantly, the judge made clear that it remained open to the petitioner to seek the court's permission. You'll have seen that he made that point in paragraph 120 of the judgment, where he said, although the respondent has succeeded on the application, it may turn out that the result is unsatisfactory to him. So the judge was not shutting the petitioner out from seeking the court's permission to bring the claims in paragraph 32.2 or 32.3. He was holding merely that the petitioner couldn't pursue them without such permission. And as my lords and my lady know, the petitioner's response to the judge's decision was not to apply for permission under Part 1 of Chapter 11. It was instead to seek permission to appeal, contending that he does not require permission to bring those claims. And with that, I think it's convenient to turn from the judge's order to the petition itself. I know you pointed it earlier, but I just wanted to highlight a few paragraphs in particular. It's in the core bundle at page 81, and it's the petition of Mr. Ntzegkoutanis. It relates to Coinomi Limited. We see that from paragraph 1. That's a company incorporated under the laws of England and Wales under the Companies Act 2006. And we see from paragraph 4 that Mr. Ntzegkoutanis is a member of the company holding 5 million shares in it. The paragraphs which the judge struck out, as my lords and my lady know, are on page 91 of the core bundle. They're both part of the prayer for relief in paragraph 32, which begins with the words, "The petitioner therefore prays as follows." The first, as you know, is paragraph 32.2, where the petitioner seeks an order that Mr. Kimionis, Coinomi Cyprus and Coinomi BVI do account and or pay damages to and or compensate the company, and of course I emphasise those words, in respect to their gains and the company's losses resulting from the conduct complained of in this petition. That's what the judge called the compensation claim. The second is paragraph 32.3, in which the petitioner seeks declarations of constructive trust in favour of the company. And I emphasise his words, in respect of such property in the hands of Mr. Kimionis, Coinomi Cyprus and Coinomi BVI as properly belongs to the company. And that's what the judge called the constructive trust claims. Those depend on prior allegations, and I think we have to begin with paragraph 15 at the bottom of page 84 of the core bundle, which pleads that Mr. Kimionis owed duties to the company, and then paragraph 25 on page 88, in which the petitioner says essentially that Mr. Kimionis misappropriated the company's property. And in paragraph 26, he says that Mr. Kimionis breached his duties to the company by doing various things. What the subparagraphs say is that that Mr. Kimionis misappropriated things belonging to the company by transferring them to Coinomi Cyprus and Coinomi BVI. 26.1 refers to particular assets, 26.2 refers to effectively the whole of the company's business and assets, and 26.3 refers to the corporate opportunities belonging to the company. And then in paragraph 29, the petitioner says that the knowledge of Mr. Kimionis is to be attributed to Coinomi Cyprus and Coinomi BVI. And then paragraph 30 says first in 30.1 that Cyprus and BVI are liable to the company as knowing recipients in respect of such of its assets as they've received, and that they hold all such assets and their proceeds on constructive trust for the company. And then in 30.2, Mr. Ntzegkoutanis pleads that Coinomi Cyprus and Coinomi BVI dishonestly assisted Mr. Kimionis in his breaches of fiduciary duty to the company, and that they're liable to the company on that basis. And as I say, those are the allegations which support the prayers for relief in 32.2 and 32.3, which the judge struck out. As you know, I say the judge was right for two reasons. First, he was right because the effect of section 260, subsection 2 of the Companies Act 2006 is that the petitioner cannot pursue those claims without the court's permission. And secondly, he was right because, as he set out in his judgment, the effect of the authorities is that the petitioner cannot properly pursue those claims in this way. And with that introduction, I think we need to turn to section 260 of the Companies Act. You looked at it very briefly before lunch. It's in the authorities bundle. I'm working electronically, so forgive me if I'm a bit slow on the tab references. I think it's tab 2. It's page 6 of the electronic bundle, page 3 of the hard copy. And this is chapter 1 of part 11 of the Companies Act 2006. Section 260, subsection 1, is where we need to start, and that contains a statutory definition of the term derivative claim. The fact that it's a statutory definition is clear from the final sentence. This is referred to in this chapter as a derivative claim. Although it could be broken down into any number of component parts, I think it's probably helpful to break it down into 3. The first part of the definition is proceedings by a member of a company. The word proceedings is important. That is a very broad term. It's not limited to any particular form of proceedings. It could be a Part 7 claim, it could be an application, it could be a petition. We don't have in the authorities bundle any of the cases like Bristol Airport and Powdrill on the scope of the word proceedings, but I think I can take it as read that it's a very broad term. And it's important just to note, while we're on the word proceedings, that subsection 2b makes clear that an unfair prejudice petition is proceedings. That is proceedings under section 994. So proceedings is a very broad term. The words member and company feature there. They're not themselves important, but the case law on the meaning of those words is relevant, and we'll come back to that in a moment. But the first requirement, as I say, is proceedings by a member of a company. The second is that the proceedings are in respect of a cause of action vested in the company. We know what the term cause of action means it's a factual situation which entitles a person to obtain a remedy from the court, as Lord Justice Diplock famously put it in Latang and Cooper. But the relevant types of cause of action for these purposes are then cut down by subsection 3, which you'll see provides that a derivative claim under this chapter may be brought only in respect of a cause of action arising from an actual or proposed act or omission involving negligence, default, breach of duty or breach of trust by a director of the company. The cause of action may be against the director or another person or both. So it follows that a derivative claim as defined may not be brought if the cause of action arises from something which falls outside subsection 3. For example, it can't be brought if the cause of action arises from a breach of contract by a third party or a tort committed by a third party, but provided that it arises from what you might call a breach of duty by a director, to put it in broad terms, then it doesn't matter if the defendant is the director or another person or both.
Can we just pause there one moment? So as you say, this won't bite on a contractual claim against a third party. In that sense, it's dealing with matters facilitatively, isn't it? It's saying when it says a derivative claim may be brought only in respect of, it's recognising that this provision is facilitating claims by a member, but then cutting down the scope.
Yes, we'll see precisely how it does that when we look at the two authorities on member and company.
So I'm not sure I'm not sure it's relevant, but I'm not sure I fully understand the point. If a director in breach of duty, deliberate breach of duty in fact, refuses to allow the company to sue another one of his companies for a debt, are you saying that this section doesn't apply if a minority shareholder says...
No, because that would still involve the cause of action.
So you're not saying that, or
I'm not saying that,
or you are agreeing that it wouldn't?
That would still have as its linchpin or foundation a breach of duty by the director in the example that you just
yeah, I understand. Yeah.
What you're saying is, suppose there's an ordinary dispute contractually between a company and someone else. Yes. The member can't muscle in and say, right. I'm taking advantage of this provision.
That's right.
He has to say the reason that the company isn't suing or pursuing a cause of action is because the directors are breaching their duty. The wrongdoers, or somebody, to use another expression, is
yes,
wrongly preventing.
It's not fundamental to my argument. I'm just saying that the second requirement involves a cause of action, but I'm pointing out it's not any cause of action. I wouldn't want you to think that I was suggesting that. The second requirement also includes the words vested in the company. This is another respect in which it's not just any cause of action. It has to be one vested in the company. In my submission, those words are clear. They refer to ownership. It's a pretty basic principle of company law that a company is a separate legal person which owns its own property. The shareholders don't have any interest in the company's property. The third requirement is then that in the proceedings, the member is seeking relief on behalf of the company. So, in other words, although the proceedings have been brought by the member, he or she must be asking the court to award some relief to the company. And what I say the words seeking relief on behalf of the company mean is as follows. It's important, of course, when we're looking at this, I'm breaking it down into three parts, but that's just for convenience. In construing it, we have to look at the definition as a whole. We've seen already it's seeking relief on behalf of the company in respect of a cause of action vested in the company. What that means is that the relief sought has to be such as would vindicate the company's cause of action, or satisfy it, or extinguish it, whatever term you want to use, so as to prevent the company from being able to sue on it subsequently, because it's gone. The the court has granted relief to the company in respect of, has granted relief on behalf of the company, should stick with the statutory language, in respect of a cause of action vested in the company.
It may have been a Freudian slip in a sense that if you seek relief, I mean, I think the point that's made against you is that the situation of a shareholder bringing a 994 petition, a foundation of which is to say there was a duty owed to the company, the duty was breached and the company has suffered loss, and that an order ought to be made to compensate the company or to pay money to the company, isn't actually within this, because what the court is not doing there is not simply saying, as a sufficient answer to the case, here's a breach, here's a duty, here's a breach, here's loss. There has to be something else, and the remedy when it's granted is not granted to the company. The remedy is granted to the shareholder who's established not only those component parts but unfair prejudice. Even though it may benefit the company, it's not a remedy granted to the company.
It's granted,
and
yes,
and you know, you're saying, well, okay, on behalf of is it in fact synonymous with, if you're bringing a cause of action on behalf of the company or you're seeking relief on behalf of the company, then the remedy is granted to the company. Those are, I think it would be said synonymous. You weren't wrong to say that. I think it would be said against you.
The statutory words are on behalf of, and there are interesting questions that we'll come on to about what you might call mixed proceedings, and I hope we can address them without shopping trolleys and holograms. But the statutory words are seeking relief on behalf of the company, and it's my submission that it's clear, particularly clear when you combine those with the earlier part of the definition referring to a cause of action vested in the company, that what Parliament is seeking to describe is such relief as would vindicate the company's cause of action.
So I think it would have said, if you're seeking relief on behalf of the company and the relief is granted, the relief will be granted to the company because you were authorised to do it.
It may not make much difference, but it's such relief as would vindicate the company's cause of action, so as to preclude the company from suing on it again afterwards. The cause of action would have been merged in the judgment granted by the court. I said I'd come back to mixed. I think I'll come back to mixed proceedings.
That wouldn't be the case, would it? I mean, just to be clear, that's res judicata in the strict sense. Cause of action estoppel that you just described.
Well, I wasn't seeking to limit it to that. I mean, such as would prevent the company from pursuing the claim thereafter.
But that is the test. I mean, the point is, if this petition proceeds and the relief that's sought is granted, the company might be prohibited from instituting proceedings again, but not by reason of a cause of action estoppel, but by reason of an issue estoppel.
Either way, it could also be Henderson abuse. It doesn't really matter how you put it. The companies.
But I think it might be. I think it might be said analytically. It is quite important because unless you could say that there was a cause of action estoppel, and I'm looking again at section 261A, then this section really isn't intended to bite.
When we come back to the Law Commission's proposals, I think it is important to bear in mind when we're looking at this that the intention was to enact a clear, straightforward statutory scheme that could be applied without difficulty, without drawing nice or fine or legalistic distinctions. We just need to apply the statutory words. The second part of the test is in respect of a cause of action vested in the company. The third part is seeking relief on behalf of the company. And I will come back to the question of mixed or overlapping proceedings where you can say, well, it's partly that, it's potentially partly something else. But I think it's important to do that when we've had a chance to look at the statutory scheme as a whole. Those are the parts of the definition. In subsection 2, a derivative claim as defined may only be brought A, under this chapter, or B, in pursuance of an order of the court in proceedings under section 994. So there are two ways, and only two ways, in which a claim falling within the statutory definition may be brought. It's clear that such a claim can't be brought in any other way. The first is under this chapter, and what this chapter goes on to provide in section 261 over the page is that a member of the company who brings a derivative claim must apply to the court for permission to continue it, and the following subsections of that section deal with the initial hurdle that a petitioner has to overcome by establishing that the evidence discloses a prima facie case for giving permission. And then section 263 provides in subsection 2 that permission must be refused in certain circumstances. And then in subsection 3, in considering whether to give permission, the court must take into account in particular, and it lists various matters. What is important about that wording is that the matters identified are matters which the court must take into account in particular. The list is prescriptive in that sense, but at the same time, the words in particular indicate that it's not exhaustive. The court could take account of other relevant matters, including convenience, practicality, requirements of case management, and so on. So that's how a derivative claim may be brought under Chapter 1 of Part 11. The second possibility, as we saw, is that a derivative claim may be brought in pursuance of an order of the court in proceedings under Section 994. That's in the authorities bundle at page 10, electronic, page 7, hard copy. If we start with the familiar provision in section 994, a member may apply by petition for an order on the ground that the company's affairs are being or have been conducted in a manner that is unfairly prejudicial to the members, including at least him. And then in 996, the court has the wide power under subsection 1. And then in subsection 2C, the court may authorise civil proceedings to be brought in the name and on behalf of the company by such persons and on such terms as the court may direct. And so that's relief that the court can grant in the unfair prejudice context. So if you're a member of the company, you want to bring a derivative claim as defined, you need to obtain permission from the court in one of those two forms.
Just to be clear, are you saying that what you're saying is the abuse here? Is it presenting the petition with this relief in it? Or is it presenting the petition with this relief in it and not seeking permission in these proceedings pursuant to section 260?
The problem is pursuing without permission. The judge made it...
So I was trying to distinguish. Do you say that it was an abusive process to present the petition with this relief in it?
No, if you applied immediately for permission and sought and obtained permission, obviously if permission were refused and you said, well, I'm going to try and pursue it anyway, that would be an abuse.
So you say that what should have happened is that having presented the petition, an application should have been made pursuant to CPR 19?
Yes, I mean, ultimately pursuant to Part 1 of Chapter 11 as the statutory source of the court's ability to grant permission and the ability of a member to seek it. But yes, and that's why I started off by saying the judge wasn't shutting out the petitioner entirely. He was saying, look, you need to do this by way of a derivative claim, so you need to get...
That's the point I've just made. Well, it's what you mean by derivative claim.
As defined in the statute.
Are you saying that what the petition in this case needs to do is to present a Part 7 claim form?
It doesn't say that in section 260, it's proceedings. And as I said, proceedings is a very broad term. It is apparent from the face of section 260 itself that an unfair prejudice petition is proceedings. There'd be absolutely nothing in the statute to prevent a petitioner from saying, well, the form of proceedings I want is an unfair prejudice petition. As I said, that is expressly contemplated as a form of proceedings in section 260 subsection 2b, which refers to proceedings under section 994, you could put it in a petition and apply for permission. If the court refused permission, it would obviously be an abuse to try and pursue it thereafter. Similarly, if you said, well, I'm not going to seek permission, then it would be abusive. But it is important to recognise, as I say, the judge wasn't shutting out the petitioner from bringing a derivative claim as defined.
The paragraph 120 to which you referred us, on the basis of which you make that assertion, the judge does seem to envisage that the petitioner actually has to go off and bring separate proceedings. And that's the only sensible way of reading, I think.
Well,
whereas in fact, I think, on any view, I mean, a derivative claim is started and then you just seek permission. And so, in fact, so the judge wasn't in fact right in what he told. Insofar as he said they have to go off and issue a Part 7 claim form and maybe have the two of those together. The true analysis, if you're right, is that just the judge should have considered whether in those paragraphs in the petition should be continued applying the Section 260 criteria.
He could have done that if the petitioner had said, well, I accept that I need permission, I'd like permission. Instead, of course, what the petitioner said, what he still says, is that he doesn't require such permission and that he can pursue those claims without permission. But that's right, and we'll come in a moment to the judge's reasons for rejecting my statutory submission. I say that they're wrong and that the judge should have accepted it. But yes, that entirely, what my Lord Justice Snowden has said entirely follows from my submissions about the width of the word proceedings. They don't have to be in any particular form. This is a definition which looks to the substance, not the form. So that is the relevant statutory scheme. I should just take you to the explanatory notes at tab 4, page 12 of the electronic bundle, page 9 of the hard copy, which simply reinforce all of that. You'll see at the bottom of the page, paragraph 494, the first bullet point, subsection 1, defines what's meant by a derivative claim. There are three elements to this. The action is brought by a member of the company, the cause of action is vested in the company, and relief is sought on the company's behalf. And then the next bullet point, subsection 2, provides that the claim may only be brought either under this chapter or in pursuance of an order of the court in proceedings under section 994. Now, I said I'd come back to the terms member and company, which appear in subsection 1 of section 260. The meaning of those terms is not directly relevant, but we need to look at the authorities because they cast light on what chapter 1 of part 11 has done to the common law that preceded it. And they explain why you have to be very careful when considering the pre-2006 authorities. And by a sidewind, they show you why you also have to be careful when looking at foreign authorities. And I'll deal first with the case law on member. Now, section 112, subsection 2 of the Companies Act, provides that every person who agrees to become a member of the company and whose name is entered in its register of members is a member of the company. That is then extended for present purposes by subsection 5 of section 260, which you'll find at the top of page 7 of the electronic bundle, 4 of the hard copy, where it says in little c, references to a member of a company include a person who is not a member, but to whom shares in the company have been transferred or transmitted by operation of law. And as you've seen, part 1 of chapter 11 applies only to claims brought by members. It doesn't apply to claims brought by persons who are not members, such as persons who are members of the company's parent company. A claim by a member of the company's parent company would fall outside part 1 of chapter 11 entirely. And that was the decision of Mr. Justice Briggs, as he then was, in the Fort Gilkicker case at tab 33 of the bundle. It's page 639 of the electronic bundle, page 636 of the hard copy.
It's since been dealt with by the Court of Appeal as well, I think.
Yes, there are other authorities to the same effect that we could have relied on. There's the decision of Mr. Justice Lewison, as he then was in Iceni and Westrip, which makes the same point generally about the effect of the provisions of.
I think there's a Court of Appeal decision called Verhoff, I think.
It rings a bell, but I think we get what we need from this. And my lords and my lady will see from the head note that C and D2 owned the LLP, which owned D1, and D2 was alleged to have misappropriated D1's corporate opportunity by taking it for the benefit of his own company, D3. So C commenced these proceedings, and you see just below D in the head note, the claimant brought proceedings alleging that the second defendant had pretended that the third defendant was another joint venture entity and had thereby misappropriated a valuable business opportunity of the first defendant for his personal benefit in breach of his fiduciary duty to the first defendant. Since that claim was solely vested in the first defendant, the claimant applied under section 260 for permission to continue proceedings as a double derivative action, a subspecies of the multiple derivative action, on the first defendant's half against the second and third defendants. And Mr. Justice Briggs set out the issue in paragraph 2 of his judgment, which is on page 643 of the electronic bundle, 640 of the hard copy, where he explains that prior to the coming into force of the Companies Act 2006, derivative actions relating to companies were creatures of the common law. It's common ground that the ordinary derivative action by a member of the allegedly wronged company was wholly replaced by the statutory derivative claim provided in Chapter 1 of Part 11, which confers locus standi on a member of the relevant company. The legal questions for decision on this application are: 1, whether a multiple derivative action was known to English common law before the 2006 Act, and 2, if so, whether the multiple derivative action has survived coming into force of the 2006 Act. And Mr. Justice Briggs answered the first of those questions in the affirmative in paragraph 26. He said, yes, there was such a thing as the multiple derivative action before the 2006 Act. So he went on to consider the second question. And the issue arose because in light of the definition of member, it was clear that a statutory derivative claim under the 2006 Act could be pursued only by a person in whose name the shares were registered or to whom the shares have been transferred by operation of law. Such a claim could not be brought under the 2006 Act by a member of a parent company or a member of an ultimate parent company. And the question was whether by not expressly permitting such claims, the 2006 Act had thereby impliedly prohibited them. In other words, whether multiple derivative actions which had formerly been possible at common law had been abolished. And you'll see the rival contentions to that effect in paragraphs 32 and 33. And Mr. Justice Briggs said in paragraph 36 that it was relevant to have regard to the Law Commission report on shareholder remedies, pursuant to which Chapter 1 of Part 11 had been enacted. And he noted that the Law Commission had said, we consider that the question of multiple derivative actions is best left to the court to resolve. And then he noted in paragraph 37 that the Parliament had broadly intended to follow the Law Commission's recommendation. And then he concluded in paragraph 44 that the 2006 Act didn't do away with the multiple derivative action. He said in paragraph 44 that first there was, before 2006, a common law procedural device called the derivative action, by which the court could permit a person or persons with the closest sufficient interest to litigate on behalf of the company. He said those persons would usually be a minority of the company's members, but they might, if the company was wholly owned by another company, be a minority of the holding company's members. And then he continued in paragraph 45. In 2006, Parliament identified the main version of that device, namely where locus standi is accorded to the wronged company's members, labelled it a derivative claim, and enacted a comprehensive statutory code in relation to it. As a matter of language, section 260 applied chapter 1 of part 11 only to that part of the old common law device thus labelled, leaving the other instances of its application unaffected. And then at 46, he held that Parliament did not expressly abolish the whole of the common law derivative action in relation to companies, even though by implication, the comprehensiveness of the statutory code, it did so in relation to derivative claims as defined. So what has been swept away is the common law relating to derivative claims as defined. What that means is that if you are looking at a pre-2006 authority about a derivative claim as defined, you obviously need to be very careful about it, because the judges in those cases were operating outside of the statutory regime that was introduced by the 2006 Act. And there's a similar point about the word company and a similar authority to the same effect. Section 1 of the Companies Act defines the word company to mean a company formed under English law, and that obviously gives rise to an issue about derivative claims relating to foreign companies, which was addressed in Nova Trust. You'll find that in the authorities at tab 36, it's page 749 of the electronic bundle, 746 of the hard copy. I'm sorry, is that in volume 2? That concerned a company called Spartan, which was incorporated in the British Virgin Islands. And one of the defendants' arguments was that although a derivative claim in respect of a foreign company had been possible before the 2006 Act, it was no longer possible at all because it wasn't expressly permissible and had therefore been impliedly prohibited. And you'll see that from paragraph 25 at the bottom of page 759 of the electronic, page 756 of the hard copy. And in paragraph 26, you'll see the applicants argue that the jurisdiction in respect of foreign companies was revoked by the operation of Part 11, Chapter 1 of the 2006 Act, because those provisions were intended to establish a comprehensive code. As I said, it was essentially argued that because those provisions didn't expressly permit a derivative claim in respect of a foreign company, they had impliedly prohibited it. His Honour Judge Pelling didn't agree. He said that in paragraph 27 in the second line, although it submitted the chapter creates a comprehensive code concerning the jurisdiction to entertain derivative claims, in my judgment, that is only so in relation to the claims to which it applies. He held that the effect of section 260 subsection 1 is that the chapter applies and applies only to proceedings in England and Wales by a member of the company, that is, an English registered company. In those circumstances, either the chapter applies only to derivative claims brought in England by a member of an English registered company and does not affect the common law jurisdiction over derivative claims in respect to foreign companies. My lords and my ladies saw that Mr. Justice Briggs, as he then was, held in Fort Gilkick. It's legitimate to look at the Law Commission's report on shareholders' remedies. That report reinforces the conclusion that Part 1 of Chapter 11 has entirely replaced the common law applicable to derivative claims as defined. And you'll find that in the authorities bundle. It's towards the end, tab 47 of the hard copy, page 1148, I should say, of the electronic. And if we start at page 1151, at the bottom of the page,
In this respect, I think the electronic version clearly wins because I don't think on the hard copy we can read page numbers except internal page numbers.
Okay, well, it's
So either paragraph numbers or internal page numbers.
internal 85, paragraph 6.51, where they say that the vast majority of respondents agreed with the provisional view expressed in the consultation question that an action which can be brought under the new procedure should only be capable of being so brought and not also under the exceptions to the rule in Foss and Harbottle. And then over the page, paragraph 6.53, they noted that diverging principles might develop between the new procedure and the procedure at common law, which would add to the current confusion, and that would go against their stated aim of making the law simpler. We consider that the only way to avoid this problem is for the new procedure to replace the common law derivative action entirely. And you also see that at the end of 6.55 on the next page in bold. We therefore recommend that the new derivative procedure should replace the common law derivative action entirely. And I'm not going to take you to any more of it, but the general tenor of it is that the Law Commission thought that the authorities were in a bit of a mess and it wanted to put derivative claims on a clear statutory footing, which would exclude the common law principles as they had been worked out in the prior authorities. And as I say, that's entirely consistent with what you get from Fort Gilkicker and Nova Trust. And that's why you need to be careful in my submission about the pre-2006 authorities, because whatever practice or procedure of the court before 2006 might have permitted the doing of certain things, the bringing of claims, now has to be put to one side, and we look first and foremost at the statutory scheme, which does two things, which was previously attempted by the authorities, and that is first, draw the dividing line between what is a derivative claim and what is not a derivative claim, and then secondly, it sets out what you need to do in order to bring a derivative claim as defined, and as I've said, that is to obtain permission of one of the two forms identified in subsection 2 of section 260. I said I'd come back to what I would describe as mixed proceedings. What if a member wants to bring proceedings which are partly in respect of a cause of action vested in the company and seeking relief on behalf of the company, and partly not in respect of a cause of action vested in the company and seeking relief on behalf of the company? Or what if not only are there two different things, but there's some element of overlap between them? What if they are at least partly in respect of a cause of action vested in the member and seeking relief on behalf of the member? Does that affect the analysis at all? In my submission, such a claim is still clearly a derivative claim as defined in the statute, and permission is still required. I said I'd hope to do this without metaphors about supermarket trolleys and holograms. So I'm going to try and come up with a better example. If Parliament has said that you need to build, you need permission to build a structure with a roof, you can't then build a structure with a roof without permission and say, oh, well, I didn't need permission because it also has a courtyard. It's still a structure with a roof. It may feature a part that doesn't have a roof, but it's still a structure with a roof. You still need permission. Similarly, if you build a structure with a roof and put a solar panel on the roof, you can't then say, well, I didn't need permission because it's a support for my solar panel. It's still a structure with the roof. It may be that the roof is also functioning as a support for the solar panel.
But I think the point is put slightly differently against you. It's this. It said, look, if you were to ask the question, what what comprises the company's cause of action? The answer is the company has a cause of action if it is owed a duty by a director which is breached, resulting in loss.
Yes.
Company, those are the constituent elements of the company's cause of action. And if you were to ask the question, what is the cause of action of the shareholder? The answer would be the shareholder has a right to apply to the court on the grounds that the affairs of the company have been conducted in a manner which is unfairly prejudicial to him.
Yes.
Those are different. The underlying facts, which might be said on the one hand to constitute the company's cause of action and might be the basis for the allegation of unfair prejudice, may be the same, they may overlap. But one is a corporate right of action and the other one is a shareholder's right to apply to the court for discretionary relief, which he may or may not get, but it depends on whether he can establish unfair prejudice. Now, we know that from the authorities that generally you can establish unfair prejudice if you establish that a director has breached his duties to the company, because that's a breach of the basis on which you become a shareholder. But it's juridically different.
It is.
And the Law Commission thought it was different because there's nothing in this paper that suggests that they were intending to cut down or limit the scope of what could be included in a 994 petition.
Yes, but that's a different point. Can I deal with that one first? There is an important conceptual difference which my learned friend entirely ignores between power and permission. The fact that the court under section 996 has power to grant a particular remedy such as compensation or declaration of constructive trust doesn't tell you by itself whether a claimant needs permission to seek it.
I was thinking not of 996, I was actually the foundational section 994. I was trying to paraphrase 994. Yes. I mean, the Law Commission in the passage you were taking us to, if you turn back a page to 611, sorry, to paragraph 611, I mean, the Law Commission set out what I think had become commonly known to everybody at the time, that as a matter of practice, derivative actions are brought far less frequently than proceedings under section 459, that's 994's now. But we don't accept means no reform should be made. There are still cases where derivative action is the only or most appropriate route to take. Whilst we noted the tendency of applicants to bring 459 proceedings in respect of matters which could have given rise to a derivative action, we don't consider the two should be entirely assimilated. They are different in principle. One gives rise to a personal right which the shareholder can enforce, the other relates to the company's cause of action. And although they may cover some of the same ground, this will not always be the case. I mean, aren't they acknowledging the point that's made against you, that the cause of action under 994 is not a cause of action vested in the company, and nor does it result in relief granted, nor does it result in somebody asking for relief on behalf of the company, or indeed relief being granted to the company. That's the argument that I put against you, that the reason that everybody has hitherto treated these two regimes as separate is because in fact 994 is not a cause of action vested in the company, even if it includes matters which could have been used to formulate a company claim.
Yes, and of course they are conceptually different, but they're not mutually exclusive. The fact that something may be one thing doesn't stop it from also being something else.
But there's nothing in any of the papers or anything that's what has gone in any of there's no academic learning, no statutory consultation, nothing to suggest that Parliament thought when it was enacting this regime that it was preventing somebody from seeking a type of relief in 994 that had hitherto been available.
And as I say, it doesn't do that. It doesn't affect the width of the court's powers. We're dealing with a separate question of permission. And what is spelt out in section 260 is that permission is required whenever there are proceedings by a member of the company in respect of a cause of action vested in the company and seeking relief on behalf of the company. It would be wrong to read in any adjective or epithet. It doesn't say proceedings which are solely or exclusively in respect of a cause of action vested in the company. It doesn't say proceedings which are predominantly, or my Lord Justice Snowden said this morning in exchange with my learned friend, purely. It doesn't say anything like that, and there's no basis for reading any words in. Provided that the proceedings are by a member of the company in respect of a cause of action vested in the company and seeking relief on behalf of the company, then a derivative claim as defined will exist. And to go back to my Lord Justice Snowden's example a moment ago, you may have a case where a member is of a company, as defined, is bringing proceedings, and he's relying on the fact that the director has acted in breach of duty. He's doing this in the context of an unfair prejudice petition, but what he's saying is, well, I'd like a buyout order. He's not then seeking relief on behalf of the company. He's seeking a buyout order for himself.
Yeah.
But as soon as he says, well, I don't want a buyout order, I'd like an order for damages payable to the company, or a declaration that certain assets are held on constructive trust for the company, or even if he says, I'd like a buyout order, and in the alternative, I'd like some relief in favour of the company, then it is a derivative claim as defined by the statute, and permission is required. It would drive a coach and horses through the statutory regime to start drawing the sort of distinctions that my Lord Justice Snowden has put to me, because it would mean in practice that the statutory requirement for permission could be avoided every time by saying, well, I'm going to put it in an unfair prejudice petition. Obviously that by itself wouldn't be enough, but the petitioner would then say, well, I'm also going to combine it with a claim for a buyout order, and then potentially not even do that. I mean, even I think on my Lord Justice Snowden's analysis, it would be the same even if you didn't ask for a buyout order. You just say, well, I'm not relying on the company's cause of action. I'm relying on my own cause of action as a shareholder. And although I'm seeking relief on behalf of the company, I'm not within section 260, because I'm asking the court to grant that relief under section 996 on the basis of unfair prejudice under section 994. And that would mean that although Parliament had set up this very careful definition and said that permission is required, you'd be able to say, well, I'm not doing solely or exclusively or purely or even predominantly that. I'm adding it to something else, and I've sidestepped the permission requirement. And it's my submission that would not be a sensible interpretation of the scheme that has been laid down by Parliament. What Parliament has said is that if you tick these boxes, you need permission, and why shouldn't you seek it? All the points that my learned friend was making this morning about convenience, practicality, and so on are no doubt points that he would wish to rely on in the context of an application for permission, but that doesn't do away with the fact that he needs to seek it and obtain it. Of course, there'd be counter-arguments as well, but there'd be arguments that would be had in the context of a permission application. They're not reasons for saying that permission is not required at all. And I think before leaving this topic, it would be helpful to look at the judge's reasons for rejecting my statutory submission, which are in the judgment in the core bundle at paragraph 67 of the judge's judgment. find that. So we start with 66 actually, where the judge said, in 66, he said that my argument was undermined by the fact that even at common law, if invited to do so, the court had to consider at a preliminary stage whether a claimant ought to be permitted to continue their derivative claim. He was essentially saying, well, there's always been a permission requirement. The permission requirement in the 2006 Act isn't really a new feature, and that's a point that my learned friend made this morning. That misses the point because Section 260 was entirely new. It had no predecessor in the Companies Act 1985 or any of the earlier legislation. So there is in fact a very clear contrast between the pre-2006 Act position and the post-2006 Act position, because after the enactment of the 2006 Act, there is a very clear statutory provision which says that permission in one form or another is a mandatory requirement. And that is a big distinction. It's not simply a continuation of the same state of affairs. As the judge said, before the 2006 Act, the court could be invited to consider whether to permit the derivative claim to continue as a matter of practice or procedure. But now, by contrast, there's a mandatory permission requirement as a matter of statutory law. So the judge's first point is, in my respectful submission, a bad point. And then in paragraph 67 of the judgment, the judge made 2 points. First, he said that the difficulty with my argument was that because the court has theoretical jurisdiction to entertain as part of an unfair prejudice petition a claim which could be pleaded as a derivative claim, it may be said that the petitioner thereby, in a sense, has their own cause of action which they can pursue. So to that extent, Section 260 is not engaged because the petitioner is not seeking to prosecute a cause of action vested in the company, even though a wholly equivalent claim could be formulated as a derivative claim. To put the same point another way, a petitioner making a claim which could be pleaded as a derivative claim makes it, in a case such as this, not relying on the company's cause of action, but on their statutory right given by Section 994 to bring a petition for unfairly prejudicial conduct. So that was his first point. And then his second point was to say that Lord Justice David Richards in the Hutt Group had said that as regards the proper relationship between petitions under Section 994 and derivative actions, consideration of the authority suggests it's highly sensitive to the precise circumstance of the case and the relief claimed. On Mr. Robbins' argument, a case would be either a derivative claim or it would not, whatever the remedy sought. And I'll deal with those points, if I may, in reverse order, because the judge's second point in paragraph 67 is just wrong. I don't say that the nature of the relief claimed makes any difference or that it's irrelevant. To the contrary, my submission is that the nature of the relief claimed is highly relevant because it's a third part of the test in Section 260, subsection 1. As I've said, a derivative claim is anything which it constitutes proceedings by a member of the company in respect of a cause of action vested in the company, seeking relief on behalf of the company. So the nature of the relief claimed is highly relevant. If it's not seeking relief on behalf of the company, then it's not a derivative claim within the statutory definition. The judge's first point in paragraph 67 is also misconceived. And we've touched on this already. The judge's reasoning seems to be that the same set of facts might potentially justify a claim by the company against the director and or an unfair prejudice petition by a member. The judge seems to have relied on the proposition that the court would have power under Section 996 to grant relief in favour of the company. And he said, well, if the member has a right to petition for unfair prejudice and the court under Section 996 could grant relief in favour of the company, then the member isn't relying on a cause of action vested in the company, he's relying on his own cause of action. I've said why in my submission that's absurd, because it would mean that a member could sidestep the permission requirement by the simple expedient of putting what would otherwise be a derivative claim into an unfair prejudice petition, saying, well, I rely on the same facts to say that I'm unfairly prejudiced.
Well, no, I'm not sure that's... You see, it's the questions I asked you earlier. The requirement under Section 260 and CPR 19 is not that you can't bring proceedings in derivative form, but you have to ask for permission to continue them. So I said to you, right, well, suppose that a unfair prejudice petition is presented under Section 994 and includes within it only a claim that the company has had a breach of duty to it and has suffered wrong and compensation should be paid.
Yes.
Your submission, I think, is that that is not impermissible in and of itself, but what should then happen is that the petitioner needs to seek permission following the CPR 19
Yes.
Section 260 route.
Yes.
There's nothing in the company's unfair prejudice proceedings rules that gives any hint that one of the things that the court should have to consider at the first hearing of the petition is whether any part of that petition requires permission under Section 260, is there?
Well, it's not something that the court would consider of its own volition. It's something that a petitioner has to seek permission for.
Yes, but the unfair prejudice proceedings rules say that on the first hearing, the court gives directions as to the future conduct of the petition. And if the first thing that needs to happen is you need to seek permission under Section 260 and CPR 19, that's the first thing that would happen. I'm just making the point that there's no suggestion in the unfair proceedings rules, which are 2009, that one of the things that could happen or might have to happen is that permission under CPR 19 should be sought.
No, but if my lord is suggesting that the 2009 rules are an aid to construction of the 2006 Act, I would respectfully disagree.
Well, I'm sort of pointing out that if you are right about your interpretation of the changes that the 2006 Act has brought, Section 260, it's a little bit odd that the 2009 unfair prejudice proceeding rules didn't envisage the possibility that somebody might have to apply for permission.
I'm afraid I don't know who drafted them.
The alternative view is that the two regimes are separate, because the cause of action under 994 is not a cause of action vested in the company for the purposes of Section 260. And if there was an attempt to sidestep the requirements of Section 260 by bringing a petition which solely sought a remedy which could and should have been brought by derivative claim, then that might result in the court saying this is an inappropriate procedure. You're abusing the 994 procedure, strike it out. But it would be only on the basis of abuse of process.
In my submission, it's a lot simpler than that. If you take a claim, my lord's example of a cause of action for vested in the company for breach of duty by director for compensation for loss caused to the company, you put it in a Part 7 claim, it's a derivative claim within the statutory definition, you need permission. If you put it in an unfair prejudice petition, it's still proceedings, the form of the action makes no difference, still a derivative claim within the statutory definition.
But the critical difference in those two situations would be that in the Part 7 claim you would have no right to do anything other than pursue a cause of action, whereas in the 994 petition there is a separate, different statutory right which you are pursuing, namely the right to apply to the court under Section 994.
But we come back to the point that they're not mutually exclusive. You could be doing one thing while still doing the other for which you need permission under the statute.
Well, I think the point is, it is said that they are, as a juridical matter, mutually exclusive. It's just that the facts and matters upon which you can rely may be common.
But even so, in such an example, the existence of causes of action vested in the company is not the essential factor on which the complaint of unfair prejudice depends. There's a conceptual difference. You're asking what is the linchpin or foundation stone of the proceedings. And if that linchpin or foundation stone is a cause of action vested in the company and you're seeking relief on behalf of the company, then you need permission.
Well, yes, but you've just phrased the question in exactly the way the statute's phrased it. If you put it differently and you say the linchpin of the 994 allegation is that there was a course of management of the company's affairs in the course of which a director breached his fiduciary duties to the company, causing loss to the company, and that was unfairly prejudicial to me as a shareholder. The shareholder doesn't make good his right to a remedy simply by saying that there was a breach of a duty owed to the company suffering loss. He has additionally to satisfy the court that was unfairly prejudicial to him, and it might not be for all sorts of reasons.
Yes, but that's where the overlap is not complete. But if the petitioner is saying, I'm a member of a company incorporated in England and Wales, I'm relying on this breach of duty to the company, this loss suffered by the company, and one of the things that I want is an order of the court for compensation to be paid to the company, then you are squarely within the statutory definition of a derivative claim. Permission is required. And that's, as I say, all that this is about. It's about whether you need permission or whether you can sidestep that requirement by saying, and I think I'm right in saying, on my Lord Justice Snowden's hypothesis, you can sidestep it just by putting those same allegations into an unfair prejudice petition. And you say, well, now it's an unfair prejudice petition. I don't actually need permission at all. If that were possible, then I don't think we'll ever see again any application for permission under Part 1 of Chapter 11, because it will be possible to put it into an unfair prejudice petition and say, well, I don't need permission now. And I've said already why I submit that is wrong, because the definition in section 260 doesn't look at the form of proceedings. It doesn't say Part 7 claim. It doesn't exclude unfair prejudice petitions. It expressly accepts, it contemplates that unfair prejudice petitions are a form of proceedings, using that broad term, and that permission would be required whenever the particular boxes that together make up the definition of unfair prejudice, of derivative claim are ticked. I've got slightly out of order. If you give me a moment, I think.
Have we covered the ground?
I think we've probably covered the ground. I've dealt with my learned friend submissions on this point in the course of the discussion. It's probably just worth picking up what he says in his supplemental skeleton argument in the core bundle at paragraph 170, because this really does highlight the core issue between the parties on this point. He says in paragraph 6 that the present proceedings are not a derivative claim as defined, because A, they're not in respect of a cause of action vested in the company, they're in respect of a cause of action vested in the petitioner. Well, he's treating them as mutually exclusive. Both things may be true. As I've said, it's partly in respect of a cause of action vested in the petitioner, partly also in respect of a cause of action vested in the company. Then in B, he says the proceedings do not seek relief on behalf of the company. You've heard what I say about that. It's very clear from the two paragraphs that the judge struck out that they do seek relief on behalf of the company. They seek that compensation be paid to it and that declarations of constructive trust be made in its favour. And then in C, my learned friend says the simple truth of those propositions is not undermined because, as part of the relief sought by the petitioner, he seeks to reconstitute assets of the company by reference to wrongs done to the company. Well, I would say let's paraphrase those words. My learned friend accepts that the petitioner seeks to reconstitute assets of the company. In other words, he seeks relief on behalf of the company. And my learned friend accepts that the petitioner does say by reference to wrongs done to the company, or to put it another way, in respect of causes of action vested in the company. So the second and third requirements of section 260 subsection 1 are clearly met. And then my learned friend goes on to say the petitioner wouldn't be satisfied by that remedy alone. He seeks reconstitution alongside further orders in relation to shares of the company, which together will vindicate his rights as a shareholder. And I think I've dealt with this. My learned friend seems to be suggesting that if you bring a derivative claim as defined in combination with something else, then it ceases to be a derivative claim and you sidestep the permission requirement. And as I say, I think I've dealt with that point. If you bring a derivative claim as defined alongside something else, then it doesn't cease to be a derivative claim. It's just a derivative claim accompanied by something else which isn't a derivative claim. I think the final point to deal with on this is that my learned friend says, well, if I'm right about the statutory submission, then the Companies Act 2006 has significantly altered the pre-existing common law position. And he says there's nothing to suggest that that was intended. There are two answers to that. First, of course, it presupposes that my learned friend is right about the pre-existing common law position. The learned judge held that my learned friend wasn't right about that. And if the judge's view of the pre-existing common law position is correct or even broadly correct, then the 2006 Act hasn't significantly altered the pre-existing common law position. It simply tightened it up by saying that it's not only in rare and exceptional cases that the court will permit a derivative action to be put into an unfair prejudice petition. There is, in fact, no exception anymore for what you might describe as rare and exceptional cases. There is now just a mandatory permission requirement.
I suppose actually there need to be an inconsistency there because you could case for the rare and exceptional case by granting permission.
Yes, absolutely. But the second point is that my learned friend's argument that Parliament can't have intended to change the common law is in any event wrong. My lords and my lady have seen from Fort Gilkicker, Nova Trust, the Law Commission report, the intention of Chapter 1 of Part 11 was to do away entirely with the common law, which the Law Commission had said was complex and confused, and to replace it with a new statutory scheme which was meant to be simple to understand and easy to apply. So Parliament plainly intended to change the law. My learned friend's assumption or assertion that Parliament can't have intended to change the law is simply wrong in any event. I think the next thing to address is the two recent decisions of this court which touch on the question.
And just to be clear, we're moving on from the statute.
We're still in the statutory submission. Yeah. And the reason I do it that way, my lord, is because the most recent decisions of this court post-date the coming into force of the 2006 Act. And my reason for going to these cases is to show that there is nothing in them which is inconsistent with the submission that I've been making. I don't think when we get to the end of them that you'll think that they are actually particularly relevant, certainly not determinative, but my reason for taking you to them is to show that there's nothing in this court's recent jurisprudence which is in any way inconsistent with the submission that I've been making. The first is the Hutt Group decision. I think it is helpful to start with the first instance decision of His Honour Judge Eyre, which is at page 1056 of the electronic bundle, 103 of the hard copy, tab 43, I believe, although I don't have the hard copy myself. And you'll see from paragraph 4 that the petitioner petitions pursuant to section 994 of the Companies Act against the first respondent and 14 other respondents. The latter respondents are persons who've been directors of the first respondent at various times, 5 of whom are also shareholders in the first respondent. Detailed points of defence have been served and we've been met by points of reply. And then he says, in 5, in the current application, the respondents seek the striking out of the petition in its entirety as an abuse of process or failing that, striking out of particular elements of the petition. And then we should look at paragraph 4 of the prayer as it comes up later. It's in paragraph 17, which is page 160, electronic, 1057 hard copy, where he says at paragraph 4 of the prayer, the petitioner seeks an order that the directors involved in the breach of duty set out in paragraphs 27, 30 and 44 pay equitable compensation to the first respondent for those breaches, and that out of the proceeds thereof, the first respondent compensate the petitioner in respect to the losses pleaded at paragraphs 29, 39, 44 and 45. And then in paragraph 41, which is page 105, 1065, electronic 1062 hard copy, paragraph 41, His Honour Judge says that the respondent's case is that the petition is in reality making a derivative claim, and he says that the relevant, this is I think a summary of the respondent's submission, the relevant distinction is that between unlawful conduct by directors and unfairly prejudicial mismanagement. Here redress is the respondents say being sought against the directors of the first respondent for breach of their duties to that company, with the relief sought involving an order that they pay compensation to the first respondent. The whole gist of the complaints, and I think whole gist is the word at the time from Charnley Davis, is said to lie in the unlawfulness of the director's alleged acts and omissions. It said that this falls foursquare within the definition of a derivative claim. That seems to be a reference to the statutory definition that we've been debating, and outside the scope of section 994, which is to address unfairly prejudicial conduct. The respondents contend it's an abusive process to bring a derivative claim concealed as a petition under section 994, thereby circumventing the restrictions on the bringing of a derivative claim. And then in 42, he says that in support of that contention, the respondents place particular reliance on the pleading, paragraph 9 of the petition, of the duties owed to the first respondent by the directors, on the averment at paragraphs 27, 37, 44 that the actions were breaches of the duties owed to the first respondent, and on paragraph 4 of the prayer seeking an order for the payment of equitable compensation to the first respondent. And then in paragraph 43, the petitioner's response is that that's a mischaracterization of the claim. It says this is a conventional unfair prejudice claim which is seeking redress against those in control of the first respondent for the fact that the affairs of the company have been conducted in a way which is unfairly prejudicial to the petitioner in its capacity as a shareholder. On its behalf, Mr. Chastey contends that the fact that the allegedly unfairly prejudicial conduct involves breaches of duties, breaches by directors of the first respondent of their duties as directors, does not mean that this is in reality a derivative claim. And then at 45, he says he was referred to a number of authorities, but he says he can state the principles comparatively shortly. And then in 46, His Honour Judge Eyre has a go at stating those principles, identifying the purpose of section 994 and saying that that's concerned to address mismanagement of the affairs of the company rather than to provide redress for misconduct that has harmed the company. He said that mismanagement could take the form of a breach of duty by those in control of the company. Same acts can be both mismanagement, which is unfairly prejudicial, and misconduct and breach of duties. And then he says the question of whether a claim is properly to be seen as appropriately brought by way of section 994 petition or as being in reality a derivative claim is a matter of analysis of the true nature of the particular claim. In that analysis, particular regard is to be had to the relief sought and even more to the nature of the complaint. And of course, I don't disagree with that. That's a reflection of what's in subsection 1 of section 260. And then he says the court has to consider whether the complaint is in reality in respect of harm caused to the relevant company by the misconduct, in which case there should be a derivative claim, or in respect to the impact on a petitioner's position and his rights as a minority shareholder, in which case section 994 proceedings are appropriate. And then after considering some of the authorities, he says in paragraph 56 that he's going to apply those principles to the circumstances of this case. It's at the bottom of 1066 electronic, 1066 hard copy, 1069 electronic, how are those principles to be applied. And he says, in his judgment, the petition is correct to say that the claim is properly to be seen as one seeking redress for unfair prejudice. He goes on to say, after the next sentence, the fact that the allegedly wrongful conduct includes breaches of duties which the second to 15th respondent owed as directors does not without more mean that the claim is a derivative claim. Instead, the nature of the claim must be considered, subject to consideration of paragraph 4, which he addresses later. The petition is not seeking to recover damages for a loss suffered by the first respondent, and there is no suggestion that the first respondent has suffered loss. And then he goes on to say it's clear when the body of the petition is considered, the complaint relates to the impact of the alleged actions on the petitioner rather than the impact on the first respondent. Similarly, when regard is had to the relief being sought, the primary relief consists of a number of orders against the first respondent. Such relief is patently not relief which could be sought in a derivative claim. It's apparent redress is being sought for the alleged reduction in the value of the petitioner's shareholding and or reduction of the petitioner's rights. And then over the page he turns to deal with paragraph 4 of the petition, which did seek an order that the directors pay equitable compensation to the first respondent. And he says that has to be seen in the context of the petition as a whole. And he says when seen in that context, the paragraph 4 doesn't change the nature of the proceedings. And his reason for saying that is then set out in paragraph 64, where he says he's concluded that paragraph 4 doesn't fall to be struck out because the relief could have been more elegantly pleaded, but seen in context, the nature of the relief being sought is clear. That paragraph of the prayer must be seen as a whole, and when that's done, it amounts to a claim for indemnification. The relief sought is compensation payable to the first respondent, but in circumstances where the first respondent is then in turn to use that compensation to make a payment to the petitioner. And so he concludes at the end of that paragraph that it's a claim which is appropriately made in the petition and which is not abusive. On appeal, you see the decision that begins, I think it's tab 45, it's 1106 of the electronic bundle. But the relevant passage for our purposes is 1116, which I believe is 1113 of the hard copy. It's in the decision of Lord Justice David Richards, where he's already noted in paragraph 43 on the previous page that the principal ground for the application was that the petition was in substance a derivative claim within the meaning of section 260 of the Act. And he says, although the respondents haven't appealed on that ground, it's worth quoting the judge's analysis, which he then sets out. And he says in 45 that he agrees with this analysis of the petition. As regards the proper relationship between petitions under section 904 and derivative actions, consideration of the authority suggests it's highly sensitive to the precise circumstances of the case and the relief claimed. Whatever that relationship may be, it doesn't arise in the present case, which does not involve any claim for relief on behalf of the company, either in substance or very largely in form. The central point in this case is that while the petition alleges breach by director-led duties to the company, it doesn't allege that the company, as opposed to Zedra, the petitioner, has suffered any loss. So that was what Lord Justice David Richards thought was the key point. The petition, when he looked at the relief claimed, wasn't actually alleging that there'd been any loss suffered by the company. The petitioner wasn't seeking any compensation for the company. It's relevant also to look at what he said about paragraph 4 of the prayer, which you'll find in paragraph 64 of his judgment on page 1119 electronic, 1116 hard copy, where he says it's true that...
Just pause there. I mean, I thought you showed us that actually the petitioner was seeking compensation for the company, but that out of that compensation, the company should pay the petitioner certain amounts. But
Yes.
It's undoubtedly the case that the first part of the claim in the petition in Hunt Group was compensation has to be
In
paid.
paragraph 4 of the petition.
Yes, that's what you
and
showed
you're
us.
coming on to paragraph
Yes, and that's
64
what,
and
that's what
65.
Lord Justice David Richards deals with in paragraph 64,
Yeah.
where he says it's true that paragraph 4 of the prayer rather oddly seeks a payment of compensation to the company, which would then apply in paying compensation to Zedra. The judge thought that was best read as a form of indemnification. I can see that if Zedra recovered damages against the company for breach of its obligation, to provide information, the company might have a claim against the directors who cause the company to be in breach. That is not, however, what is sought by paragraph 4, which presupposes a liability of the directors to pay compensation to the company, independently of any liability of the company, etc. And he says in 65, I do not consider that paragraph 4 can be retained, at least in its present form, and I'm also unable to see its value, even if it's reformulated as an indemnity. And so he strikes out paragraph 4. And so I say that's entirely consistent with what I say is the right approach. If they'd wanted to bring a derivative claim as defined in the statute, then they should have obtained permission.
But he's not, sorry, just to be clear, the reason I picked it up, I thought you misdescribed what paragraph 4 said, but he's striking this out on what, reflective loss grounds?
Well, he's just set out the judge's
Yes, but he's not.
analysis and says he agrees.
Yes, but he's striking out paragraph 4.
Yes, because that's where he parts
reflective
company.
loss grounds.
Well, sorry, maybe I missed it, but I'm not sure where. It seems to be that he's striking it out on the basis that it can't be retained in the unfair prejudice
No, I
position.
mean,
It's not
sorry,
entirely.
I read this as, paragraph 61 of the judgment. This is under grounds 5 and 6. The challenge was that the judge was wrong not to strike it out. And 62 on the grounds it's barred by the rule against reflective loss.
It's not entirely easy to follow the grounds of appeal or the reasons. I mean, the reasoning in paragraph 65 is entirely it's compressed. But as I said, my reason for taking my lord to my lady to this is to show that there's nothing in it which is inconsistent with what I say is the correct approach.
He's not, sorry, okay, well, he's not striking it out on the grounds that it needed permission as a derivative claim.
As my lord has pointed out to me, I don't think that's quite the way in which the argument at this stage was being put. But there's nothing in it that is.
I was just trying. I hadn't picked up the reference to reflective loss, and I was then trying to work out how it applied. But I see at the end of 63, I think Lord Justice David Richard says it doesn't apply.
Oh, I see. Yes, I'm sorry, I missed that.
Or maybe not. I'm not sure.
Well, my point for present purposes is that there's nothing in it that can be said to be inconsistent with my submission. And the reason that's important, of course, is if there was anything in it that was inconsistent, that would be a decision that bound this court and predetermined the answer. But there's nothing in it that is inconsistent. The same applies to Taylor Goodchild. And we begin with the first instance decision of my Lord Justice Snowden, tab 44, page 1082. And as my Lord will recall, in fact, my Lord's plural, it's a case in which there was an unfair prejudice petition resulting in a buyout order in favour of Mr. Goodchild, who thereby obtained control of the company. And then the company, acting by Mr. Goodchild, sued Mr. Taylor in respect of matters that predated the unfair prejudice proceedings, and on which, in fact, Mr. Goodchild had relied to establish unfair prejudice, and that's what my Lord explained in paragraphs 5 to 8. There was then an application by Mr. Taylor for summary judgment on the basis of Henderson abuse, and my Lord Justice Snowden held that Mr. Goodchild could have pursued the company's claims in the unfair prejudice petition. That's paragraphs 48 to 50. And that's entirely right. I don't disagree with that. He could have pursued the company's claims in the unfair prejudice petition. The proceedings would then have involved a derivative claim as defined by section 260 subsection 1, and Mr. Goodchild would have had to seek permission, but there was nothing to stop him from doing so. That's something he could have sought to do. My Lord Justice Snowden held that the DLA claim didn't meet the could and should test for Henderson abuse, but the whip claim and the account of profits claim did. And my lord said, paragraph 87 at page 1101 of the electronic bundle, 1098 of the hard copy, it was perfectly possible, in my judgment, for Mr. Goodchild to seek the relief now sought through the whip claim and the account of profits claim as part of the petition. And as I say, that accepts that's something he could have done. He'd have needed to seek permission, but there was nothing to stop him from seeking it. And then over the page, paragraph 89, my lord said, the issue is whether it would have been possible for Mr. Goodchild to have formulated and pursued an order for the same relief for the benefit of the company in the petition as is now sought in the current Part 7 claim. For the reasons set out in the authorities, I consider that section 996 is quite wide enough to have covered all such relief. That's right.
Oh, I said 88, 89.
Yes, sorry, 89.
Yeah.
That's right as well. As I've said, we're not concerned in this appeal with a question about the breadth of the court's power in the unfair prejudice context. We're concerned with the logically prior question as to whether someone who is a member of an English incorporated company and brings a certain type of claim requires permission. My Lord Justice Snowden held that Mr. Goodchild should have pursued the whip claim and the account of profits claim as part of the petition, and then therefore struck out the whip claim and the account of profits claim on the basis of Henderson abuse. The decision of this court is then at tab 46, page 1125 of the electronic bundle, 1122 of the hard copy. My Lord Justice Newey sitting with Sir Nigel Davis and Lord Justice Moylan. And my Lord Justice Newey agreed with what my Lord Justice Snowden had said about could. That's paragraph 30. And again, as I said, I don't disagree with any of that. It wasn't really touching on the question of whether permission would have been required. But no one, in any event, was suggesting that there had been anything to prevent Mr. Goodchild from seeking such permission as he may have required. Where my Lord Justice Newey differed from my Lord Justice Snowden was on the question of should, in the could and should test for Henderson abuse. And at paragraph 31, my Lord said that there's more scope for argument, however, as to when it is appropriate for the court to grant relief in favour of the company in unfair prejudice petitions. And my Lord mentioned China Davis and Waddington, and then which have touched on that debate. And then at paragraph 47, my Lord said, in the present case, Mr. Justice Snowden took the view that Mr. Goodchild could, both in principle and practice, sought in the context of his unfair prejudice petition the relief that the company is now claiming, that the court would have had jurisdiction to grant such relief under section 996 is not in dispute. And as I said, I don't agree with that. This isn't an issue about the court's powers, it's about the logically prior question of whether permission is required, and no one was suggesting that Mr. Goodchild couldn't have sought permission to the extent he needed it. My Lord Justice Newey continued, however, it's not always abusive to raise later a claim that could have been put forward earlier. And the first point that my Lord Justice Newey made by reference to Chime and Waddington was that Mr. Goodchild couldn't have put forward this claim as of right. It's a bit more complicated than that. And then my Lord Justice Newey said, in the present case, the pursuit of the whip claim and the account of profits claim and the unfair prejudice proceedings would not merely have involved their being advanced by a shareholder rather than the company, to which liability is said to be owed, but would have required the joinder of an additional party, STL, incorporating the whip and account of profits claims in the unfair prejudice proceedings could also have been expected to complicate and delay the proceedings in other ways. And so my Lord concluded at the end of that paragraph that the fact that Mr. Goodchild might have sought to pursue those claims in the unfair prejudice petition didn't justify a finding that pursuit of them later was an abuse. So ultimately, the decision was a fact-sensitive analysis of the should aspect of the could and should test for Henderson abuse. Sir Nigel Davis saw it in the same way. Page 1146 of the electronic bundle, paragraph 50 of the decision, where he said that he accepted Mr. Goodchild could have sought to introduce into the unfair prejudice proceedings are derivative claims in respect of WIP and account of profits. The real question is whether he should have done, such as failure to do so renders an abusive process of subsequent proceedings. And again, in terms of a fact-sensitive analysis of the should aspect, he said it wouldn't have been straightforward and wasn't an abuse to pursue the WIP claim and the account of profits claim separately. And Lord Justice Moylan agreed. So ultimately, as I said, it's my submission that Taylor Goodchild doesn't actually have any bearing on the present case as to whether or not permission is required to bring the claims which the judge struck out. In terms of other post-2006 Act decisions, the only other one I think I should look at from this jurisdiction is tab 34, Apex Global Management and FI Call Limited, decision of Mr. Justice Voss, as he then was, page 657 of the electronic bundle. And the point was whether in an unfair prejudice petition, a third party who was not a member could be made jointly and severally liable with a member to buy the petitioner's shares. And the passage that my learned friend relies on is paragraph 125 at page 684 of the electronic bundle, 681 of the hard copy, where, as my lords and my lady saw earlier, the judge said, in my judgment, these authorities speak with one voice. And he said that sections 994 to 996 provide a wide and flexible remedy. And then after 126, there's a heading, issue 1, whether as a matter of law, if the facts were established, relief under section 996 could and should be granted against each of the third, fourth and fifth respondents. And as I said, that relief was in the nature of a buyout order in that particular case. And then he said at the bottom of the page over onto the next page, it's true that none of the third to fifth respondents is a shareholder in FI Call, but the authorities clearly show that does not prevent relief being granted against them. The relief could take the form of orders that they restore money they improperly caused to be paid away by the company, or compensation for damage to the company caused by their wrongdoing, or an order that they buy Apex's shares in the company. And my learned friend relies on this paragraph to say, look, the court hearing an unfair prejudice petition would have the power to make orders requiring respondents to restore money that they improperly caused to be paid away by the company, or pay compensation for damage to the company caused by their wrongdoing. And that's entirely right. I don't disagree with that. As I've said, it is irrelevant because we're not concerned with the question of whether the court has power to grant such relief. We're concerned with the logically prior question as to whether a member who seeks such relief requires the court's permission in order to do so. Permission and power are not the same thing. But no one would ever dream of saying this court doesn't have power to overturn a first instance judge's decision because an appellant needs permission to appeal in order to get here. They're conceptually separate. So paragraphs 125 and 128 of Mr. Justice Voss's decision in Apex don't support my learned friend's submissions because they're irrelevant to the permission question. Before moving to anything else, I think it's worth turning briefly to a decision from another jurisdiction. As I said, one has to be rather careful because their company's legislation is usually drafted in different terms, and we can't just transpose unthinkingly what has been held in other countries to the English context. But the decision of Gray and Ledger at tab 31 of the authorities bundle, page 651 of the electronic bundle, does shed some helpful light on the, what I say is a correct approach to the issue. It's a decision of Mr. Justice Bannister in the BVI, and he explained in paragraph 1 that it's an application by the first defendant, Mr. Ledger, that the claim made against him by the claimant, Mr. Gray, in these proceedings be struck out. Alternatively, that Mr. Ledger be granted summary judgment against Mr. Gray. It's a complaint that's then summarised in paragraph 2. And paragraph 4 sets out the prayer for relief in the petition, which seeks, among other things, in subparagraph 2, a declaration that any assets in Mr. Ledger's name acquired with company money are held by him on trust for the company. And in subparagraph 6, an order that Mr. Ledger repay all sums and other benefits found on the taking of the inquiries to have been received by him, other than assets held on trust for the company, in respect of which an order is sought Mr. Ledger transfer such assets to the company. And Mr. Justice Bannister explained in paragraph 7 that Mr. Mays relied on chime to say that it's an abusive process to put what is essentially a derivative claim into an unfair prejudice petition. But then in paragraph 8, Mr. Justice Bannister says he gets very little assistance from the authority, and he makes the point that Hong Kong company law seems to be different. And then in paragraph 9, he says, in my judgment, the position here in the BVI is clear. A derivative action requires permission under section 184C. In considering whether to grant permission, the court here is mandated to take into account a number of important considerations. The court may not give permission unless it's satisfied that the company itself does not intend to make the claim and that it's in the interest of the company. The conduct of the proceedings should not be left to the company, etc. That's all rather similar to what we find in section 263. He says these conditions are of so stringent a nature that in my judgment it's an abusive process to attempt to mount a derivative claim without the consent of the court under section 148C. If that permission is granted, then it seems to me it's a matter of case management, whether the derivative claim is prosecuted as part of the unfair prejudice proceedings or is tried together with them or separately. But to attempt to bring such a claim without permission is, in my judgment, an abuse. And of course, although we're dealing with differently worded statutory provisions, that is rather helpful by way of support for my statutory submission. It's important to make clear that there is no equivalent in the BVI of section 260 subsection 2, which makes the position even clearer in this jurisdiction. Because what Mr. Justice Bannister was doing is saying, well, there's a statutory requirement to obtain permission for this sort of claim. The existence of the statutory requirement for permission shows that you can't do it without permission. It says in the BVI statute you need permission. It didn't say expressly, and you can't do it otherwise. It just said you need permission.
We don't find in this report section 184C.
No.
I don't suggest we should spend time on it now.
I can provide it if it would assist, but
If following the hearing, one or both of you could send through section 184C, it would be helpful.
The key point about it is it says you need permission. It doesn't say, and you can't do it without permission. I say the position's stronger here because not only do we have a statutory provision that says you need permission, we've also got one in section 260 subsection 2, which says, and you can't do it without permission. So it's even clearer in this jurisdiction. And obviously, when we go back to look at the heads of relief that were in the unfair prejudice petition, in that case, they're conceptually very similar to the heads of relief that were struck out by the judge in the present case. So before looking at any other authorities that predate the 2006 Act or that come from other jurisdictions without the provisions of the 2006 Act, I would just summarise my statutory submission as follows. First, Mr. Ntzegkoutanis is a member of a English incorporated company who has brought proceedings, and an unfair prejudice petition is a form of proceedings. Secondly, He's done so in respect of causes of action vested in the company. He's pleaded duties owed to the company. He's pleaded those duties were breached. He's pleaded that the company has suffered loss and damage as a result. And he's done that in order to constitute causes of action vested in the company, factual circumstances which would entitle the company to relief. And thirdly, in the paragraphs which the judge struck out, he sought relief on behalf of the company. We looked at those paragraphs earlier. One of them was what the judge called the compensation claim.
I just wonder whether, given the time constraints, Mr. Robbins, you're better assuming we've got those.
Yes, I'll assume, in which case that you got that point. We looked at them. We looked at those paragraphs earlier. As I've said, it's not particularly helpful, given that we're now operating in a statutory context, to look at the pre-2006 Act authorities. But if and to the extent they are relevant, they do, in my submission, support both my statutory submission and the judge's alternative reasoning. The first authority to look at briefly, we've seen it before, is Charlie Davies, which is in the bundle at authorities bundle at tab 15, page 268 of the electronic bundle. It was a petition under section 27 of the Insolvency Act 1986, as originally enacted, an unfair prejudice petition complaining about mismanagement by an administrator. And I think it's fair to say it's apparent from G on page 263 of the report that everything that Mr. Justice Millett said was entirely obiter, because he says in that paragraph, this makes it unnecessary to decide the remaining question, viz. Whether a sale of the company's assets by an administrator with negligent undervalue is sufficient without more to establish a claim to relief under section 27, but the question has been fully argued, and in deference to the submissions of counsel, I've endeavoured to answer it. In my judgment, it's not. So it is obiter, but of course it's relied on subsequently, so it ends up being rather more significant than pure obiter. And on page 624 of the report, which is page 287 of the electronic bundle, after quoting from a decision of Mr. Justice Peaton in a case called Sam Weller relating to unfair prejudice petitions, Mr. Justice Millett says just below H that he respectfully agrees. An allegation that the acts complained of are unlawful or infringe a petitioner's right is not a necessary averment in a section 27 petition. In my judgment, it's not a sufficient averment either. The petitioner must allege and prove that there are evidence or instances of the mismanagement of the company's affairs by the administrator in a manner which is unfairly prejudicial to the petitioner's interests. Unlawful conduct may be relied upon for this purpose, and its unlawfulness may have a significant probative value, but it's not the essential factor on which the petitioner's cause of action depends. And I rely on that in support of the submission that I was making earlier about the conceptual distinction between a cause of action vested in the company and a shareholder's complaint of unfair prejudice. It may be that the same facts can be relied on to establish both, but they're still conceptually separate. The shareholder does not rely on the fact that the company has a cause of action. He relies on the existence of the unfair prejudice in order to establish his claim.
Isn't that against you? Because isn't he making the point that a petitioner's cause of action is distinct and different from the company's cause of action?
No, it supports my submission because he's making the point that to establish the unfair prejudice, the shareholder may be relying on the same fact, but he's not relying on the fact that the company has a cause of action. It's not the existence of the company's cause of action that establishes the unfair prejudice. In the rest of the
unlawful conduct that he mentions there is the cause of action of the company, isn't it?
Exactly.
So he's saying, well, the company's cause of action is not the essential factor on which the petitioner's cause of action depends. So he's saying that the petitioner's 994 cause of action is not the same as the company's.
Exactly. That's entirely right. The petitioner relies on unfair prejudice, and the same facts or some of the same facts may assist him to establish unfair prejudice, but he's not relying on, in the ordinary case, on the company's cause of action. If, however, he says, well, I want to rely on the company's cause of action in the unfair prejudice petition, and I want to seek relief on behalf of the company, then in the 2006 regime, he needs to obtain permission to do so. The rest of the decision is a good example of a judge operating in the pre-2006 Act environment, trying to identify the dividing line between derivative claims and non-derivative claims, and trying to identify the circumstances in which you would be permitted to put a derivative claim into an unfair prejudice petition. And as I said, that's not an exercise that this court needs to engage in because that exercise is now being performed by Parliament. But to the extent that it's held to be of continuing relevance, then I do submit it's a helpful attempt to identify that dividing line and to explain when proceedings on one side or the other are appropriate. The same submission is made in respect of Chime Corp at tab 20 of the authorities bundle. It's not a decision on the 2006 Act, but what you see both Mr. Justice Bakery and Lord Scott doing is to try to identify the dividing line or demarcation, and to identify as a matter of practice or procedure when it's proper to pursue a claim that could be characterised as a derivative claim. Given the time, I don't propose to go through it in detail. It's a lengthy decision.
But you accept it's really a case on practice and procedure, and
that's exactly my point. That Lord Scott is operating in a world without a statutory code that says if it ticks these boxes you need permission. He's approaching it on the basis of the court's practice and procedure, and hence you get in paragraph 61 references to whether it would be proper for the court on this petition to entertain what would in effect be Chime's actions against the directors for their breach of duty.
so if you're wrong on the interpretation of section 260, it all comes down to a question of case management.
Well, it comes down to a question of practice and procedure. It's not, yeah.
Well,
It's
I'll call it practice and procedure. That's the old sort of wording. Let's call it case management, shall we?
Yeah, if you were to say that by putting what would otherwise be a derivative claim into an unfair prejudice petition, then you sidestep the permission requirement entirely, then it does become a question of case management as to whether it would be appropriate. But then the case management discretion would have to be exercised on the basis of the principles that are identified in the authorities, and the judge set out those principles in his.
I think what's said again. I think if you're wrong on section 260 and this absolutely needed permission, then the fact that certain parts of this petition could have been formulated as a derivative claim but weren't, then brings into play just simply the questions of case management, doesn't it?
It would do, yes, but as I say, to be exercised.
That's not the basis on which the judge struck him out.
Well, he exercised case management discretion by reference to the principles established in the authorities, which hold that it's an abusive process in circumstances like these to shoehorn a derivative claim into an unfair prejudice petition. So it's ultimately a question of discretion, but discretion to be exercised on a principled basis by reference to the precedents, and that's where the pre-2006 Act cases and the foreign cases would come in. To return to a point my Lord said a moment ago, of course I accept, and I said earlier, that all the points that my learned friend relies on about practical convenience and so on are no doubt points that he would want to rely on in the context of an application for permission, and there'd be an argument about that. But it doesn't do away with or abrogate the permission requirement. It's a mandatory step under the 2006 Act.
And just pausing there, and I quite follow you say this isn't a question for today, but suppose you end up at some stage dealing with what's convenient, or putting it differently, case management. Here, what's asked for is a buy-in order. Is it possible sensibly to conceive of that being addressed satisfactorily at a trial without also addressing the alleged company claims? Because how does it work? You don't want to hand over your shares on the basis that the company has no claim in circumstances where when you've handed them over for nothing, the company then sues you for the full amount of the claim. Come that point where you're trying to work out how a buy-in would work, don't you need to know whether the company does indeed have a claim and for how much, or roughly?
Well, as I say, when we talk about case management, it's on the basis of the principles and the authorities that establish it's an abuse. But if my lord was to say, well, put those to one side, let's deal with it purely in terms of the overriding objective, then there would no doubt be a debate to be had between the parties. I'm afraid it's not one that I've given any thought to or come here today prepared to advance, because it's not one on which any ground of appeal or anything in the respondent's notice brings into play. But
it is the practical consequence of what you're urging on the
well, the practical consequence of what I'm urging first and foremost is, as I've maintained throughout, that if you have a statutory derivative claim as defined, you need permission, and that's something for the...
My lord's simply asking you, if you're right, what then? I mean, you know, so
well, as the judge said,
let's assume we're on the permission stage, the permission application.
We'd have that argument, but as the judge said, that's where we should be. It's for the petitioner to apply for permission to bring a derivative claim, and then we'll have that argument. But that's not, I'm afraid, what we're here dealing with today. We're dealing today with the question of whether he can do this without permission, and it's my submission, as it was before the judge, that he can't. I see the time. I'm not going to be able to deal with all the authorities, but there is one that another foreign authority that I submit is very helpful conceptually in understanding all of this, and that's the decision of the Singapore Court of Appeal in Hou Kong.
I must say, I'm glad you're taking us to that, in the sense it's very long. So if you could distill it, that would be helpful.
I will. What the Court of Appeal of the Republic of Singapore is grappling with is...
Where are we?
I'm sorry, my lady, it's page 871 of the electronic bundle. And the relevant passage begins at page 918 of the electronic bundle, page 915 of the hard copy, where they say at 84 that they refer to their prior decision in a case called Ntzegkoutanis, and 5 lines up from the bottom they say that...
Sorry, just going...
I'm so sorry.
You just,
And I've just had an exploding
I've
file.
got an exploding file.
I'm so sorry.
It's all going wrong. Could you help me again with the page reference?
918. And at 84 they refer to a decision called Ntzegkoutanis, and 5 lines up they say that in that case, A, the plaintiff's complaint appeared to be based on the corporate wrongs that could have been pursued by way of derivative action under section 216A, and B, the plaintiff was essentially seeking restitution to the company of amounts that had been misappropriated from it by the wrongdoer. And then over the page they say they further emphasise that section 216, which is their unfair prejudice provision, should not be used to vindicate essentially corporate wrongs for 2 broad reasons. First, the overly permissive interpretation of section 216, allowing it to be invoked to vindicate wrongs to a company, would be contrary to the legislative scheme, which provided for the commencement of a statutory derivative action on behalf of the company, subject to its own safeguards under section 216A, to remedy such wrongs. and secondly, permitting an essentially corporate wrong to be pursued by way of an oppression action under Section 216 would be an abuse of process as it improperly circumvented the proper plaintiff rule. And then at page 922 of the electronic bundle, 919 of the hard copy, they've compared unfair prejudice petitions and derivative actions. And then they say at 91, notwithstanding these important similarities, it's clear the two causes of action are ultimately intended to have distinct spheres of application. And they explain what they mean by that. And then over the page at 93, they say, for these reasons, we affirm and reiterate the view we expressed in Ntzegkoutanis, that Section 216 should not be used to vindicate wrongs which are in substance wrongs committed against the company, and which are thus corporate rather than personal in nature. It's a long authority because they review the case law in various jurisdictions, including in this jurisdiction, they look at Charnley Davis, they also look at Chime from Hong Kong. And then at page 934 of the electronic bundle, page 931 of the hard copy, at paragraph 116, they say that they consider it appropriate to remind themselves that while the legislature has not seen fit to clearly demarcate the boundary between the two types of actions, what can be deduced in view of the similarities and differences as between them is that in the endeavour to appropriately delineate that boundary, it would be relevant to have regard in particular to the kind of remedy sought, these being wider in one type of action than the other, as well as the kind of injury that is complained of for which the remedy is sought. And they say it's unsurprising that in many of the cases reviewed, the courts have sought to identify the dividing line between oppression actions and statutory derivative actions by examining the remedy sought and the injury complained of. And they say that the appropriate analytical framework to ascertain whether a claim that's being pursued under Section 216 of the abuse of process is as follows, and they set out their test. It looks at the injury, it looks at the remedy. And the reason I say that's very illuminating is because they are doing that in the absence of any statutory demarcation, as they have put it. They say it falls to the court to delineate. The Court of Appeal of Singapore had to have a go at drawing that dividing line, and they said you have to consider the injury complained of and the remedy sought.
And if we look, and I don't suggest we should do it now, we will find the terms of those sections in this report.
I believe so. I'm afraid I don't know that off the
No.
top of my head. If they're not in there, my learned friend and I will get them
Please.
and
But
provide
I wouldn't
them.
spend time on it now.
The importance of that, as my lord and my lady knows, I say that this court is not in the same position as the Court of Appeal of Singapore, because here the legislature has seen fit to demarcate that boundary in the three-part test in Section 260, subsection 1. It's drawn that dividing line, and it's said that if you fall within the definition, then permission is required. That's the legislature's decision in respect to the appropriate procedure to be followed. And that, in my submission, as I said, is what you see going on in Charnley Davis and Chime. In the absence of that sort of statutory provision, the courts themselves are trying to work out what appropriate dividing line should exist, and whether and in what circumstances you should be permitted to bring what is essentially a derivative claim in an unfair prejudice petition. I see the time. If my learned friends have any time to reply, I think I need to sit down now, unless my lords and my lady have any further questions for me.
No. Thank you very much, Mr. Robbins. Ms. Bailey.
My lords, my lady, I'll endeavour to be brief. As it evolved, my learned friend's case centred almost wholly in my submission on what he terms the statutory submission, and he didn't seek to engage in a substantial way with the reasoning of the first instance judge, not based on that change in the legislation by way of supporting that reasoning. And for the reasons I set out this morning in my submission, that reasoning should not be accepted. My learned friend also accepted, as I understood it in the course of looking at Charnley Davies, that the petitioner's cause of action is not the company's cause of action. And yes, in my submission, it's fundamental to his case on the statutory submission that really in practice the two are one so far as the territory he's concerned with. And what in my submission my learned friend didn't really have an answer to was the question posed about whether or on what basis he suggested that there would be a cause of action, estoppel, or a merger of judgments, as it were, on the company's cause of action.
Can we just pause there then? What you're asking for is relief in favour of the company, to use a neutral expression, including a declaration that assets are held on trust for the company. Assume you failed in that. Could the company bring a new claim?
No, but not because of a cause of action estoppel. And that's the fundamental analytical point in my submission. There would inevitably be issue estoppels that prevent.
Why wouldn't there be cause of action estoppel?
Because in the petition, it would not be the company's cause of action that had been asserted and determined.
But the company's cause of action would have been determined.
Well, with respect, no, not as a matter of analysis. And this comes back to the conceptual distinction, because what the petitioner is doing is seeking, if the petitioner establishes that his cause of action is well made in the sense that he satisfies the requirements of section 994, he then invokes, and that's on the basis of the unfair prejudice, if he establishes that, he then turns to section 996 and seeks to invoke the court's remedial jurisdiction under that section. And that's the basis on which he seeks the orders that he seeks.
I see all that. But you're saying, I want a declaration that these assets are held on trust for me, and I want money to the company in respect of the wrong done to the company. Doesn't that determine the company's claim?
Well, Lord, I accept that it does in practice. I fully accept that. And so the reason the distinction is important in my submission is that it is important as a matter of analysis as to what's going on as between the two causes of action, which are crucially distinct. And so, and
I mean, we don't have Zodiac here, which is what we really need for this. But I thought the point that you were making was that for a cause of action estoppel, the causes of action needed to be the same.
yes,
And you say the shareholder's cause of action is a personal cause of action which depends on demonstrating unfair prejudice.
precisely.
And along the line, he may make good the allegations of duty, breach, and loss and damage.
Yes,
But that, which gives rise to an issue estoppel,
precisely.
but it's not a cause of action estoppel because the
No.
causes of action in the two sets of proceedings are different.
Yes,
In practice, it would be an issue estoppel, which is
Yes.
why the company couldn't continue to say, well, I know the judge in the first set of proceedings decided, for example, that there was no breach. But that's because the issues were decided in proceedings between the same parties.
yes.
I just wonder whether this is overly sophisticated. I quite follow you bring your claim for unfair prejudice, but as part of that unfair prejudice claim, you assert that the company has a claim in respect of which you want relief in favour of the company. You get it or you don't get it. doesn't that determine the cause of action?
The basis of the unfair petition, though, is not the company's claim itself.
I quite follow. And if you didn't seek any relief in favour of the company, then no problem arises because that's not the basis on which you're bringing the claim. But if you choose to include in your petition a claim for relief in favour of the company in respect of a cause of action that the company has and get relief for it, why hasn't the cause of action been determined?
Well, Lord, but it's the distinction between relief in favour of the company and relief in respect of a cause of action of the company. And the former is true here, but the latter is not. Although the relief is sought in favour of the company as part of a wider form of relief that's sought ultimately to vindicate the interests of the shareholder, which are ultimately the only thing that matters on a petition, it doesn't follow, indeed it can't be the case, that that is a claim on behalf of the company. It's only a claim by the shareholder. It doesn't have to assert the company's claim, and it doesn't.
You do really.
Well, it's the distinction between what happens as a matter of practicality, and that's going to be relevant at the level of remedial discretion, of course.
But as I understand it, there's a distinction between asserting the you say there's a distinction between asserting the company's claim as such, which is what Section 260 is about, and somebody who has a separate cause of action under 994 asserting that the facts are as follows: duty, breach,
Yes.
loss, which, had it been asserted by the company, would have been sufficient for the company to establish its cause of action. You say, well, it's not the company asserting it. You're asserting it as the stepping stones to your unfair prejudice remedy under 994. And what's more, it's not good enough for you to assert those underlying building blocks. You also have to establish that they constitute unfair prejudice.
Precisely, Lord.
And you say that it's a difference between asserting a claim on behalf of the company and asserting the component elements of that which, had it been doing so, the company would have asserted as its claim.
Yes.
And you say there's a critical distinction between the two.
Yes.
So the company would be, if it's a party and issue is stopped, because all the relevant, it's party to the proceedings, and the issues, was there a duty, was there a breach, was there loss, have been determined against the company if you lose.
Yes.
So the company couldn't then turn around and sue again. But that's not because the company's pursued its own claim, or indeed there hasn't been anybody doing it on its behalf.
Yes.
The oddity is, you say, well, the judge has determined the breach, the judge has determined the duty, the judge has determined the loss. But it doesn't stop there. You want an order that the loss be paid over. That's a remedy.
But only on the basis that that's available under Section 996.
But it isn't just that the judge has determined all these issues, fine, but you actually want the claim to be vindicated.
Well, there may be circumstances in which this is an objection at a level of case management to matters proceeding in this way. And I accept that, but it is just a matter of case management. And plainly it doesn't arise here, because when one looks at the practicalities of the matter, it makes complete sense for these matters to be determined together. But one could imagine a case where there will be substantial problems caused. What happens there is there's no objection in principle to the petition being used in this way, but on the particular facts, there is the risk of an injustice. And this is a point, for example, the company could raise, or a third party could raise, who's joined in the way that is in this petition. But in terms of the conceptual analysis that is material to the question before the court today, I hazard to suggest that actually the hologram way of putting it is in a sense helpful, because I think what it's driving at is the importance of the different perspective And so something takes on the very same thing takes on a different perspective as between the two forms of action. And so the fact that one may have the very same elements shouldn't lead one to say, therefore, what we have is a derivative action. And that's where my learned friend's point on the statutory submission falls down. That's the fundamental point. I'll be very brief on some additional points, but the point about in terms of what Parliament intended, Lord Justice Snowden referred to the further passage in the Law Commission report about the specific intention there to continue the parallel regime, reflected as well in the court rules. And one could also note in that context the very same point made in the Yassini case, if I'm pronouncing that correctly, the authority of Mr. Justice Lewison. I won't take the court to it, but it's tab 27, and what he says at paragraph 83. He says in terms, he explores the statutory change in quite some detail, and then describes section 994 as a parallel regime, and that's plainly, in my submission, the right analysis. The other significant point my learned friend raised was this suggestion that absence there being a permission requirement in the context of a section 994 petition where there's overlapping remedies, as it were, you would end up in what he described as an absurd position, and one would do away with the need for every single permission application for derivative action. Well, that's not right for the reasons I explained this morning, because there are plenty of circumstances in which the petition just will not be available because you won't be able to establish the unfairly prejudicial conduct. And in that situation, obviously, that path is not available, and what is available is the derivative action, and by way of the statutory regime for that action. There was then quite a lengthy passage of submissions seeking to, as it were, explain away post-2006 authorities. But in my submission, in a sense, that's neutral, because none of those authorities support his point. I accept that the argument hasn't been specifically raised, and it can happen that no one thinks of a point and then it is thought of and it's engaged with and there's a different answer. But certainly those authorities can't possibly help my learned friend. There was then the power versus permission point, but that relates back to the overarching point about the conceptual distinction, but it also plainly leads to a very convoluted reading of section 994 in circumstances where that has been reenacted in precisely the same terms. So it would be very odd if the effect of that was that in respect of some versions of what one could seek within the relief under section 996, you had to go and seek permission, but none of that's set out in that part of the 2006 Act. And again, that just hadn't been noticed by Parliament in reenacting section 996. I think the only other point, and it's just a minor point of detail, but in relation to the Hutt group and what was going on in relation to the striking out of head 4 of the prayer for relief in that case, the answer, I think, and I don't suggest it particularly takes the argument in either direction, but the answer, I think, emerges from paragraph 63. The difficulty there, as Lord Justice David Rich has analysed it, in respect of the slightly odd prayer for relief, as he termed it, seeking payments of compensation to the company, which would then be applied in compensation to the shareholder. But fundamental problem appears in paragraph 63. It's apparent from the petition that none of the matters complained of caused any loss at all to the company. So that's the problem, because this is a case all about allegations of dilution by issuing new shares and modifying the articles in breach of a shareholders' agreement.
That does sound like a problem, and it doesn't sound like a reflective loss problem. It just sounds like a problem.
Exactly. So he says the reflective loss point is misconceived, but he also says seeking relief in the terms that were sought is misconceived because it's premised on a loss to the company, but
And
there's no possible. There just isn't one.
Yes.
So I think that's the answer on that. But Lords, my lady, unless there are any further questions, those are my submissions.
Thank you very much, Mr. Mather. As I think you'd anticipate, we won't be giving judgment here and now. We will reserve our judgments in accordance with what is now normal practice. Of course, they'll come out electronically rather than through a courtroom. In accordance too with normal practice, you'll be supplied with the judgments in draft for you to correct our English and our typing, but not to re-argue the case. Will, I know, have very well in mind the embargo which has recently been reiterated by this court. Should there be a wish to disclose the draft judgments to anyone who is not within the ordinary scope of the embargo, then you should please raise that with us. We would hope that you could agree an order dealing with consequential matters before the hand down. If that proves not to be possible, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. But thank you both very much for very helpful submissions.
Thank you.